policy research. I'll just take you through the rules once again. The chairperson will begin with the opening remarks, and then each of the two speakers will then express their views individually. The given time is about 8 to 9 minutes, post which there will be a group discussion. After that, as you all know, the floor will be open for a Q&A session. Over to you, ma'am, to take over.
Thank you, everyone. It's an honor to be here and to be chairing this session. It's a fairly important session, and yes, we have our final speaker, Mr. Arvind Datar. It's really an honor to be here, part of this panel of eminent lawyers who are here. And the topic for today that the panel will be speaking on is, do our law schools produce world-class lawyers? I was here at this conclave earlier in the day, and we heard the session on healthcare and education of girls. And, when we saw the video of, where the person was carrying the dead body of his wife without access to healthcare, you really think of whether, law school or law education is that urgent. Certainly primary school education and healthcare are such glaring needs. But really, at the end of the day, if we want to protect our rights, our right to healthcare, right to education, right to dignity, we have to go to the courts and the lawyers and the judges. And so therefore, the question becomes all the more important that what are our law schools producing? So first, I'd like to ask, what do we really mean by world-class lawyers? What should be the kind of lawyers that our law schools should produce? Our law schools go on to produce lawyers, law practitioners, judges, government officers, ministers, politicians, teachers, and scholars. And in all their roles, we are practicing the law, interpreting the law, changing the law, using the law, and enacting law. And so therefore, there is, I would say, a very important relationship between legal education, the practice of law, and the functioning of our legal system. Now, in this regard, if law schools and legal education has such an important role to play in how law is practiced and how our legal system functions, then what should it be that our law schools should be doing or should be producing? Now, there are two schools of thought that are there. One school of thought is that there are some legal educators who believe that law schools should be like an academic department of any university, like any academic department, where it should be research and knowledge that should be pursued. There should be, research, knowledge, scholarship, and, the pursuit of truth. That should be the main intellectual activity. In other words, students should be learning the law. There is another school of thinking, and that school of thinking, that school of thought believes that the law school is a professional school, like medical school. It should produce lawyers who are going to go and practice. It should prepare its graduates to be competent practitioners who should know about the legal profession. That's what they need to produce. Now, I'd like to give you, so there are these two dividing, often dividing viewpoints that should you be really learning the law and, learning the nitty-gritties of the law and, really enjoying the, what the law is in its in-depth analysis, or should you just be focusing on creating competent practicing lawyers and know the rules of the court, how to argue in court, how to litigate, and how to address a case? I just want to give you an example. When I graduated from law school, the first day I joined the office of a very senior lawyer, and on my first day of work, I was sent to court on a case. I was given a file and asked, go and argue this matter. It's an Order 39A case. I mean, embarrassing enough, I had no idea what the lawyer told me. I had no idea what Order 39 was, what part of the law it was, which law it was. I went to court, and when I went to court, I started addressing the judge. When I said, Your Honor, just as I said, Your Honor, the first thing the judge told me is, you're standing on the wrong side. You are the defendant, stand the other side. So neither did I know how to practice, nor did I know the substantive law. So both these situations, at least I feel our law schools are not equipping our law students to be competent at when they come out. To this, I would like to add a third dimension. A third dimension really that I would like to add, that we must explore, is the connection between legal education and public interest. Ultimately, legal education should be the pursuit of justice, or should be in the interest of justice. And when we talk of legal education and public interest, I'm talking about what are our law schools teaching law students about social justice issues, about issues that our world is facing today, about inequality, injustice, and how should they pursue their legal profession and legal career. Do our law students, when they come out of law school, do they know that majority of the poor actually do not have access to courts? They cannot afford lawyers. And if they cannot afford lawyers, how are they going to get adequate representation? How many law graduates, when they come out of law school, really even think of pursuing or being a legal aid lawyer or doing legal aid work? I think most law graduates, when they come out, they want to join very snazzy corporate law firms because those are the glamorous jobs, and envisage themselves doing corporate law work. So how do we then produce law students? How do our law schools then produce law graduates who will take up cases of public interest, who will take up cases of women, children, people with disabilities, people of sexual minorities, people who cannot afford lawyers, and take up social justice issues in their profession? I think this certainly is an issue that our law schools have to address. They are not addressing it adequately. And with that, I end, and I hope some of these questions will be taken up by the other panelists. Thank you.
My dear young children, ladies and gentlemen, thank you, Indian Express. Thank you, Dr. Vaidya. Acquisition of knowledge versus impregnation of knowledge. That's the choice in deciding whether you evolve experts or you evolve the average. It's very interesting. In fact, it gave us an opportunity to explore how legal education has progressed and how the legal frontiers of education have progressed. Take the input-output mismatch. Legal education in India was pre-British, pre-independence period, was confined to the affluent families who could go to London and do law. Then take the Supreme Court from 1950 to 2016. The vintage classic judgments, you will find it in the first 25 to 30 years. You will find the best legal luminaries arguing the best constitutional points. So, they have never had formal education the way we wanted, in the prototype way we had aspired for it. They got educated. They took to practice, they interacted with judges of eminence, and they could get the best in the form of judgments, laying down the path for the nation. This has been the roadmap of practicing law. Let's understand the roadmap of academic institutions. We never had full-time colleges. We never had full-time teachers. Whenever you normally say, why are you a lawyer? Why are you a lawyer? We could not afford a seat anywhere else. No college asked us to come, and therefore we are invited here, and therefore we are a lawyer by default. This was the foundation of legal education in India. And in 60 years, we now have reached a stage of competitive education. Like engineering and law, students aspire to join law institutions. It's happening in the last 5-10 years. Standardization has come. So there is a mismatch in the input-output ratio. You had eminent jurists, you had great judges, you had great judgments. Even today, after traveling enough, I'm saying this, even today, we have wonderful judges in the country and still have wonderful lawyers. But considering the academic progression and perfection which we have been trying to achieve in the last 60 years, is the output matching with the input? The answer certainly is no, because there is fallen standards. Why? And what can be done? Any professional excellence, any professional education, let's understand, especially children are here, you must understand, it comes by nurturing. It comes by learning the craft through the rote. You don't learn it through books. You need not necessarily learn it out through an institution. So, let's take 2 examples. The magnet and the needle. As long as the magnet is within the radius, it attracts the needle. But it cannot make the needle a magnet. A magnet shall ever remain a magnet, and a needle shall ever remain a needle. This is the disability any institution which is institutionalized has it. Irrespective of the area of progress, irrespective of the area of academic pursuit, this is the basic limitation. That's why our script, I've been listening for the past one and a half hours about ancient and modern. Our Gurukula, all these excelled eminent jurists and eminent judges have undergone not institutionalized Gurukula Vasakam, but a personal Gurukula Vasakam under their seniors. Why? Our scriptures say there is something called a philosopher's stone, Sparsamani. What can it do? It's gold, and when it touches a metal, it is capable of converting it to gold. That's the difference between magnet and a needle. A needle can never become a magnet, however much you may put an effort, unless otherwise there is a transmission of its through. Whereas in a philosopher's stone, you just by intake, by glance, by pursuit, by contact, by action, by infusion, you can make one more philosopher's stone out of it. Now, how do we now do that in an institution? You can't say, therefore, all of you go to some Gurukulam. It's not possible. You need degrees. You need academic qualifications. You need graduations. You need to have some sort of... So how do we do it? See, today, the difference between 30 years and now, when we were the first batch of 5-year integrated law in 1983 to 1988, now 35 years have passed. Now the difference in the education is this, in legal education. What connects a university and a student? Let's take that very clearly. What connects the university and the student? Curriculum? Conference? Seminars? Guest lectures? Moot courts? And in some universities, exchange programs. But what is required to produce experts out of these institutions? The curriculum, the conference, seminar, is all done in controlled conditions. They modulate your behavioral patterns. They infuse you some sort of an idea of how to progress in the profession. But they don't allow you to emulate an experience of expertise. I want to say these 3 E's. Emulation, experience, result is the expertise. Now, how do we do these 3? Is it possible in an institutionalized manner? I feel it is possible. Dr. Chandra was speaking yesterday he used an expression, I was told, phygital. It's not digital, not technology. He used a nice expression, phygital. What do you mean by phygital? Find out the physical infrastructure and match it with technology. Bundle both together and deliver it, it is going to have an impact. Can we do that in legal education to produce experts? Let me tell you how. What is the physical infrastructure available to you? An institution. We have now very good institutions in the country, as much as we have some bad institutions too. Let's not worry about it. See, in public domain, it's always better to talk in a positive manner. And with young children here, we should give them hopes. So there are good institutions available today in the country for legal education. Be certain about it. So that's the starting point. Now, two, you have eminent retired judges and eminent judges serving the judiciary today. Eminent. You have the resource. You have eminent jurists, 80 plus, still 6, 7 people are still there. If you ask, they would have traveled 3 generations, 4 generations of legal pursuit. You still have such experts. And below them, you have still very good, a platform of senior counsels across the country who have gained expertise in their various fields and professions of practice. Then you have good people, public intellectuals available to contribute to you on the social aspects. Can't we not videograph their experience? It's difficult to bring them to each university and make them speak. It's not possible. So why don't we standardize and capture their best of experience and the best practices, what they feel out of the experience is good, to add value into your professional career. Then make it available. Make it available for universities, children to read and to listen, watch and experience. This is one area which this is possible. You have the infrastructure, you have to match it with the digital mode and then bring it to the campus of a university. It's not going to be very difficult. They will do it lovingly. They are waiting for such things, people to reach to them, to do that. This is one area you can possibly think to produce expertise. Now the second area is we should cut down. It's no use teaching them 35 subjects. Let them choose a few subjects. They understand how to read law. 30 years back, we had one moot competition in South and one moot competition in North. Today, we have hundreds happening week after week, at least 10 competitions happening across the country. So, they know how to read a law, including certain basic constitutional provisions. These children are trained. So, don't dump them with too much of syllabus. Let them spend 50% on academics and 50% on experience. Instead of just going for a 1-month intern, can they spend 3 to 4 months in courts after the 3rd year, 3rd, 4th and 5th year? Second suggestion. Now, the third suggestion is, can we convert our examination systems to these professional colleges into an open book system so that you don't have to really be worried about mugging up or trying to memorize when you have better. Ultimately, it's enhancement of skill. Ultimately, that is where we must work for, not produce more people with academic marks. So can you cut down the size of the subjects and just give 50% for this and 50% for practicals? Third suggestion. And the fourth suggestion, in fact, 6 months back when I was talking to the National Judicial Academy for judges, this is what when we have enough colleges across the country, let these children be aligned with the respective courts. Work on the basic file and they can really contribute in reducing dependency, and in the process they will learn by experience. These are all practical things. If you work 10 files in a year, who motivates you? How does it motivate you? Well, ultimately, what motivates you is when you do a case. My last 2 minutes. We ultimately dish out 4 sets of people from and out of a law institution. Most of them join the corporates because it is attractive and there is a immediate social recognition. Therefore, there is a flair for corporate employment. When I say corporate, government, going for employment in general. The second space is for litigators who aspire to be in litigation. The third space is for people who study and do research. And the fourth one is for very few but rare but happens, social activists, if you do become social activists after pursuing law. Now, at least for the three litigators and people interested in research and social activists, a legal education should fundamentally give them fundamentals. In the case of a litigator, creative thinking and advocacy. In the case of students interested in research, analytical thinking and global reach. In the case of a social activist, it's very, very fundamental and important that they must understand history, the value system, and social awareness. Their social awareness is just 15 years old, most of them, where you require centuries of knowledge before you can become a social activist. So, these three is something which, if an institution can give, you can produce experts not only as litigators, you produce good research scholars out of India. Please understand, it's a hope I'm giving to each one of you. Our judgments of the Supreme Court on various laws which has cross-border impact and analysis is being, our judgments of the High Court and Supreme Court is constantly discussed in international fora. This is a standard of judgments which is continuing to produce with good judges and with good counsels and with good cases coming up to courts. So all this is happening in India and it's opening up. We are having a lot of cross-border, and now you see group exchange studies are happening and people want us. So there is a need from and out of India across the world. There is a lot of hope. We should produce experts. And finally, one request to a lot of students here being here, I request you, if you want to be a good lawyer, you should be passionate about three things. It's a must. Only then you can grow yourself as a wholesome lawyer. You must love your country. Passion to the country is paramount. 2, passion to our culture. And 3, we must integrate and invest our time in knowing our constitution more than anything else. These 3 C's, in court language, there are 3 other C's. You should never even hear it in your life. But we should substitute those 3 C's with these 3 C's. Country, culture, and constitution. Thank you so much.
Good afternoon, everybody. And I must thank New Indian Express for inviting me to speak at this topic. The question asked is, do our law schools produce world-class lawyers? And without batting an eyelid, I can say yes, but not enough. We have very, very good world-class lawyers, but I wish we had many, many more of the world-class lawyers. Just a brief background, my friend Venkatraman mentioned about how the entire profession of law has changed. Of course, when we look down of our history and our constitution and so on, we remember the great lawyers, Motilal Nehru, Tej Bahadur Sapru, you had Alladi Krishnaswamy Iyer, all these were great lawyers. But let us not forget, at that point of time, law was not the profession of choice. Many people came to law college as a last resort. And I'm a student of the Madras Law College, and there used to be a joke that nobody would walk the footpath next to the law college in the early 40s and 50s, because if they found you, they'll catch you and put you into law college, because nobody was joining the law college. In fact, after I did my BSc Honours, I started getting involved in the law, and I immediately, by choice, decided to take up law and cost accounting. And after I finished both, I had gone to my hometown in Pune, and I told my aunt that I'm going to become a lawyer. I've decided to enroll, and she was absolutely horrified. And the first reaction was, who will marry you? So that was the immediate reaction in Marathi. So from that place now, after the advent of the law schools in the late 80s and 90s, the law has become, in many cases, a profession of choice. The salaries and the money you get matches other professions. See, no matter how much we talk about wisdom and culture and great values and so on, ultimately money is the driving force. Let us not mistake about it. And let me tell all of you youngsters, there is nothing wrong with money. Money well earned is the most noble thing that you can do. So don't have this thing that money is bad and wisdom is good and all. I don't believe in that absolute I think it's absolute rubbish and balderdash. The definition of money is it is the harvest of productive work. And you earn the money in proportion to the services you render to society. And again, it's issue of demand and supply. So if your aim is to earn money, no problem. But only thing, remember, money should be the byproduct of your excellence and not should be the aim by itself. So coming back to the national law schools, I find that today the quality of the students who come are truly outstanding. I don't intend to flatter you because I get interns right through the year. And when I see those young boys and girls performing, they have capacity and knowledge which we did not have at the age of 30 and 35. So I find that the quality of the students are improving year after year. The only regret I have is many of them go into corporate jobs and not enough join the legal profession to practice. It's their personal choice. Again, at the age of 20, 24, if you get a very handsome salary, it's difficult not to be seduced by that. Nobody wants to wait for 10 years to settle in the bar. But I try to tell my young friends that, look, if you're willing to wait, then the rewards are enormous in terms of personal satisfaction and in terms of daily achievement. As a lawyer, believe me, I don't have a single boring day in my life. Every day, I'm already planning next week what are the interesting cases to argue, what are the new strategies you adopt and so on. So every day is a fascinating challenge as far as lawyers are concerned. Now, if you take the legal landscape, what is the position today? We have 17 lakh lawyers. I just spoke to the Bar Council of Tamil Nadu before I came, and I was told that there are roughly 17 lakh lawyers in the country and 90,000 lawyers in Tamil Nadu. Take the number of cases. As far as the statistics of 2012 are concerned, there are 2 crore 80 lakh cases throughout the country, that is 28 million. And out of these 28 million, 4 million are in the high courts. So 40 lakhs are in the high courts and 2.8 crores are in the lower courts, the district courts, the magistrate courts and so on. So it's roughly a ratio of 6:1. And I remember in a seminar, Justice Venkatraman, one of our greatest Chief Justices, said that out of every 100 cases that go to a criminal court, hardly 5 ultimately reach the Supreme Court. So if you take the pattern of litigation, I think one problem which we have to address is how to produce very competent lawyers at the district court level and the subordinate court level. What happens is the best of the lawyers, they all want to go to the Supreme Court directly, which is, I think, a terrible mistake. You have to work your way up, but then this is a particular position which can't be ignored. Now, the other thing which I want to tell young students is, please do not be glamorized by a foreign education. I think today what happens to every law student is every law student wants to go and do a degree in LLM. It could be LLM in some Timbuktu university, but he wants to go abroad and do an LLM. Let me tell you that it is not necessary at all. And if you look back, when I wrote the book on Palkhiwala, Courtroom Genius, he had come first class first. Palkhiwala's record was he came first in every subject in all the years. So it's an unbroken record and it will never be broken. It can be equaled, but it cannot be surpassed. So there were 6 subjects in first year, 6 subjects in second year. So he came first class first in each subject in each year. And when he was told, he was a Parsi, he had the Dorab Tata Foundation, he could have got a scholarship for the asking. But he said there is no need to go abroad, I'll stay back and do well. And believe me, I can give you example after example. You take Palkhiwala, you take M.K. Nambiar, you take Ram Jethmalani, K.K. Venugopal, Soli Sorabji, none of them have gone abroad and all have done splendidly well. I'm not saying that foreign education is bad, but I'm saying that that is not necessary to achieve professional excellence. So remember that, and I personally believe in spending 2 years abroad, you're wasting your time, you're wasting your father's money. You would perhaps be better off by doing work in a court and learning the ropes here. That's my personal view. Now, what suggestions do I make? Because I really sincerely believe that the future is very bright. And I don't mean to flatter my young friends, but let me tell you, when I see all of you and I see your grasp, your ability to use the internet, your ability to pick up subjects very fast, I really feel that the much better days are ahead. I can say, achhe din are ahead of us. And now, what are the solutions which I think I should do? Because I've been giving part-time lectures in various law colleges. Dr. Vaidya Subramanian is there. I've been once or twice to his place. Venkatraman goes more often than me. Now, 3 points I want to mention. First is we must stop any more law colleges. There are just too many law colleges. Yes. And what's happened is every state wants to have a national law school. If you read the Times of India about 2 weeks ago, there is some Chhatrapati Shahu University in UP. I don't know, Chhatrapati Shahu is from my Maharashtra state. What he's doing in UP, God knows. But there is Chhatrapati Shahu University in Uttar Pradesh, which has started 88 law colleges in the last 4 years. 88. Now, physically, there are not enough lecturers for these law colleges. And if you, I don't know how many of your law students, if you read the judgment of Yashpal versus Center for Science, they had a mushrooming of universities. At one time, there used to be a number of universities, and there would be a university which was just above one tea shop. There will be a university board, you'll get a degree and you move on. So I do not know whether the Bar Council is paying sufficient attention to regulating the law schools. One thing we must remember, with quantity, quality always suffers. The reason why chartered accountants as a profession are far more competent, far more disciplined is because the threshold of passing is very, very high. So unless you have, why was the ICS coveted? Why is the IAS coveted? Why is the IIT coveted? Because not everybody can get there. So the moment you have quantity, quality will suffer. So I think the immediate need is to have perhaps a PIL to check up on all these mushrooming law colleges, shut them down if they are not competent enough. In any way, place an embargo for at least next 5 years, no new law colleges at all. For example, for the life of me, I don't know why we read a national law school in Srirangam just because the Chief Minister's constituency is in Srirangam. I mean, suppose you're from Port Blair, are you going to start a national law school in Port Blair? I don't know the logic. You might as well develop the Madras Law College, which is such a fine place next to the High Court. So the first point I'll make is no more law colleges. Second point, and which is the most unfortunate part of our legal education, and luckily I was one of the last beneficiaries of the system, is the system of part-time lecturers. Go to any great lawyer. Do you know that Justice Chandrachud, the senior, was a part-time lecturer? Palkhiwala was a part-time lecturer. Anil Diwan was a part-time lecturer. In Bombay, the government law colleges starts at 7 o'clock in the morning. The first set is 7 to 10. And then there is a day college. And many, many successful lawyers go there, take lectures, and then go to practice. And students get the benefit of that. When I was a student, the reason why at least I know some lawyers, because they're outstanding lawyers who used to come to law college, because the High Court is just next to the law college. Just cross the gate and you're in the law college. And all the important subjects, contracts, evidence, constitution, was taught by practicing lawyers. For some reason, I do not know, they've discontinued that thing, and only people who are full-time academics teach the law. I don't know if I'm wrong, but I think medicine and law, at least some of the subjects, are better taught by practitioners. A CRPC, a criminal procedure code, or an Indian penal code will be better taught by a practicing criminal lawyer than by a pure person who's academic. Of course, there are subjects like jurisprudence, legal history, which can be taught by academicians, but many subjects which are daily practiced in the courts must be taught by practicing lawyers, in my view. Last thing I wanted to mention was, there is not enough research publication. I'm on the editorial board of Supreme Court cases, but we hardly get any articles. In the law faculties, I think all of us agree there are very, very little research publications. It should perhaps be made mandatory that unless you publish X number of papers, you will not get your tenure, you will not get your permanency. I've also been trying to tell the law journals that have a prize system. Give cash prizes to attract lectures. In fact, I'll tell you one thing. The Venkatraman mentioned that we have very good national law schools which are competent. Now, in the Palkhiwala Trust, every year we conduct an essay competition. And this year we had an essay competition on arbitration, which we just finished in Delhi. And all the three prizes, top class essays, did not come from the main national law schools, but from the other law schools. So there are equally good lawyers in other law schools who may not be able to get into the admission because just by a fraction of a mark you miss the subject, but that doesn't mean you're competent enough. You can still do well. And law is one subject which is not unforgiving. If you miss getting into a top law school, there's no need to lose heart. You can still work extremely hard and make up. Because David Ogilvy said, if you're half as good but work twice as hard, you will go 4 times as far. So I would tell 2 things. These 3 points I mentioned about no more law schools, have part-time lectures, have more think towards research publication, and to all those of you who want to pursue a legal career, You can certainly do so. It is still a very, very important thing. There is enough room at the top. And just remember one thing, there are mathematical rules which apply to every profession. We talk of, we generally say good old days, all standards have gone down. The usual thing which I don't agree is standards have gone down, all good old days are there. Everything is, and that's the standard from Plato. If you read that Plato's thing, there's a very beautiful passage where he says, students don't have any interest now, all are interested in drinking and going out with girls and so on. That is in 2000 BC. So this same thing continues. If you read 1930 AIR, the journal section, that author Bunsen Agarwal writes in 1930, standards are gone down, lawyers are not studying, all the good old days are there. So we keep on lamenting the good old days and say that the present is wrong. That is not true at all. Every generation will have 10 or 15% top class lawyers. You'll have 40-50% of average lawyers, and you'll have 10-15% of useless lawyers or lawyers who are not doing well at all. This is a general makeup in medicine, architecture, everywhere. It's a human nature. So we can't just judge an era by the top 10 people who are practicing. See the thing as a whole. And believe me, in many, many cases, I just asked my interns to tell me what are the plus and minus points. Uniformly, all have told me that today there is much better infrastructure. In almost all the law colleges, there are adequate budgets for libraries. The buildings are better. The infrastructure is good. They only lament two things, that they want more specialized faculty and they would like practicing lawyers to come and teach them. So with this, I will wish all of you all the best. And those of you who want to practice law, I would say please do so. It's a great profession. And to my mind, I will not change my profession for all the money in the world. It's a fascinating, fabulous profession. Thanks.
So now I think we can open up the panel for some questions, but I have actually one question which I'd like to get your views. You, Mr. Venkatraman, you mentioned that, law students should spend more time in court during their law school education. And I mean, this is something that I totally agree that, they should spend more time in court, because moot courts are not exactly what prepares them. They should, like in medical school, you actually go to a hospital. Law students need to go to court. So would there be, shouldn't we, start some, clinical programs where actually law students can assist lawyers in ongoing cases in some way, or basically go to court in some way? Mr. Datar and Mr. Venkatraman.
See, moot court is not a bad idea for the reason it encourages a student to acquire the tools of opening up a law. And you see, in his university, there's a professor, full-time professor, to train people in moot courts. There's a full-time professor, and he really motivates children. So it's an asset. Moot court is something which is good. It gives them the experience without having to fail in a big way. So that way it's good. But as you said, in fact, me and Vaidya, we share one dream. It hope it comes true one day. After all, most of the court hearings are public open hearings. So, sensitive constitutional issues, sensitive crime issues, wherever it happens, whether it's High Court or Supreme Court, we should have a live, when we do parliamentary sessions, live day in and day out. Most of them don't watch at all. But we should find a live coverage of only then you will see how judges react. How do they, we stood for 4 weeks before a 9-judge, myself, Datar and other senior counsel, and every day was fascinating, every day was puzzling, every day was baffling. End of the day, we'll come back and say what we did for the whole day. After several years of experience, this is what we confront. So, we should allow important court cases to be screened to law institutions. So you should not, we should adapt ourselves to this digital technology. It need not necessarily be 7 to 10. Academic timings, we should all suit this to ensure that people, end of the day, acquire knowledge. The last one, as you were saying, people now, all the students from the first year go for intern for about 3 weeks, 4 weeks in every semester. I don't think that works. In fact, as Datar will be inviting, we have a lot of interns. Everybody gets a lot of interns. they should work for a schedule of at least 3 months with somebody, not 3 weeks. It doesn't serve any purpose. So you must have the system in such a way that between, say, October, November, December, or between March, April, May, whenever court functions, active time, those 3 months from the third year, the children should be doing intern. You need a 90 days internship in a year. Otherwise, it's not going to be fruitful. These are the 3 suggestions I thought I should give.
Yeah, I agree with Venkatraman. In fact, now in England, they have started screening the UK Supreme Court proceedings, and those of you who can go to the Supreme Court website, you can't download it, but you can see, for example, Brexit, should UK come out of the EU or not. Fascinating argument before the Supreme Court. Beautifully done. It's 1 hour and 40 minutes. You can see it. So that's a good idea to have, like Lok Sabha proceedings, and will be, of course, more disciplined in court. So you can hear that. As far as interns coming to court and following court proceedings rather than moot proceedings, there's one difficulty which happens now. When I was a junior in the 80s, you start a sessions case on a Monday. There was no criminal trial, or say 302 murder case. There'll be no adjournments. And I remember my senior going to Trichy or E Road and so on. The case starts on a Monday, non-stop it goes on to Saturday. So that's a great learning experience because you have people coming on a Monday, the accused, investigating officer, doctor, everybody is examined, arguments take place, and the whole thing gets over in 6 days flat. Unfortunately, now what happens is, you start a trial on Monday, then it's adjourned again after a month and so on. So this question of an intern going to court, he may not be able to follow one case, but I make it a point to tell my interns that you must spend the time in court. From 10 to 5 you must sit. Keep a notebook with you. You'll find senior lawyers arguing. Keep making notes. If they cite some case, note it down, come back and read what it is. And it's all we learn, the experience we learn from our seniors. They become our role models. We try to imitate the best in them. I would agree that, yes, you must go to court, and Venkatraman's point is well taken. Maybe 3 months is a good time. I don't know how all law schools are going to adjust to that, but I say even 4 weeks. I find one thing, that's the fact of life, you can't help it. But to say that the poor don't, that's also not correct. The other, which all my criminal lawyer friends tell me is, the biggest problem they face is the trial by media. We're speaking in New Indian Express. They say if it's an Arushi case, then even before the trial starts, they have completely decided who is guilty. In fact, I was shocked to see in Times of India, there's a report, who's this recent lady, who that, Shishira Bano, that chap, Peter Star TV chap? Huh? Sheena, yes, and Peter Mukherjee, yes, Star. Times of India says, our investigation team has found. I mean, who's Times of India to investigate? Investigation is by the police. So, and there was a report that when the Arushi murder took place, in the Hindi channels, 72% of the TV time was spent on Arushi. And I believe before, the TV channels also destroy a lot of evidence by going into the place and making all sorts of things. So, I appreciate your concern, but it is not always true that the Sanjay Dutt's and the Salman Khans get better off. There are a lot of people who get convicted also. See what happened to our Chief Minister. Yeah.
I'll add a sentence because you're a young child asking this. We must go to the root of the issue. See, democracy, the foundations of democracy is compromise, tolerance, and persuasion. Democracy stands on these legs. You must understand that. So you will have aberrations in any society, but aberrations are always an exceptions. As a child, you should not be influenced by aberrations. You have, as he rightly puts it, there are still good courts. There are still good judgments. So we should hope that we should work towards that and be part of that collegium. Okay? Good luck.
Thank you, sir.
Very good evening to the panel. My name is Raja Ram and I'm currently pursuing the 3-year law program from Delhi University. My question is about the 3-year law colleges. Both the panelists spoke about, in fact all the 3 panelists spoke about the 5-year colleges. There seems to be apathy towards the 3-year colleges. And is there anything done, or if you are aware of whether it might be phased out, or what's going to happen with 3-year law colleges, and whether they actually need any kind of refurbishment?
Had the Minister of Law, State of Law to be here to answer your question. But see, at least I don't see a difference. The difference between 5-year and 3-year, in fact, Bakshi, there is a lot of reports. Professor Bakshi, Mother Menon, they've all worked out to ensure social subjects are added in the first 2 years to mold you. That's the whole idea of a 5-year law college. And from 3rd, 4th, 5th year, the same legal subjects are retained. Okay. So, this is flip side. If you see the upside of a 3-year, you are more mature to take law because you are graduated. I would now suggest if there are youngsters, 12th standard, 11th standard students, I would suggest, in fact, I made that mistake with not knowing it. If you are an engineering discipline, if you are a maths, physics, chemistry student, do a good engineering course and then do law. You have a brightest future. Hereafter, engineering and law is going to be a good area of practice for the next 3 decades. That's a combination. So don't worry about 3-year or 5-year. You should be a successful lawyer.
Yeah. No. And in fact, I want to add, there are very few 3-year law colleges left, which are offering the course. And I agree. I think, from the 3-year law colleges, I think students come out having a better first degree because you've done a BA or BCom or BSc, and that's a much more intense and a better degree because I think sometimes in the 5-year course, the BA part is not taught that well. And I think, we find students who come out of the 3-year course, in fact, much more better equipped to take up law because they've done a graduation. I think some of your programs, I don't know whether you have a full day kind of program or just like the government law college where you just have a morning session. It gives you also the opportunity to do a lot more kind of practice work during your part-time practice work during your 3-year program, which would actually be extremely beneficial. So I would actually say that it should not go. The 3-year program should be there. It offers a lot of people who've not thought of law initially to actually take up law, because otherwise you're stuck. You have to do the whole 5-year program again.
Well, if you ask me, frankly, I think these 5 years were a very, very big mistake they have made. I'm a great votary of a 3-year law school. You must have a basic degree and then go. I very often feel a student at 17, 18 is not able to make up his mind and he takes up law school. My son is also from a law school, so I think it's better. In fact, if you do a BCom degree and then do law, you're much better off doing commercial matters, taxation matters. If you're a science graduate and this chance of trademark patent law is better. I think that the old pattern was the best because I've seen both sides. A basic degree and perhaps we used to have the BJL in those days, fundamental 2-year course in law, and the 3rd year are elective subjects. You can choose labor law, industrial law, taxation law, combined with apprenticeship. That was the best possible thing. But anyway, I think 5 years has come to stay. But don't worry, don't feel bad. I think you're better off.
Yes.
Good afternoon. My name is Kavya Srikumar. I study in MOP Vaishnav College for Women, and I'm a journalism student. My question is to you, ma'am. In your speech, you had mentioned that many lawyers won't take up legal aid law because it's not as lucrative as corporate law. Is there any model that you would suggest that would make them take it up, like an incentivization, or perhaps for corporate lawyers to take up community service hours, just like how we college students are asked to do the same thing? Perhaps they could do that side by side. Would there be any incentivization or model that you propose as a solution for this problem?
I think that's a very important question, and I think we should start really looking at some of these issues. Yes, there can be different forms of incentivization. I think in the US, some corporate law firms do pro bono work, and they consider it, they do it free of cost because the corporate firm is able to withstand it because of their high earnings, and they do it as a matter of pride and interest to do pro bono work. And they encourage some of their associates to do it, but we don't have that kind of culture in India. We have a legal services authority which actually takes on their panel lawyers for legal aid work, but they're paid so poorly that most lawyers, young lawyers who would want work in their initial years would not even think of doing it because you would get a paltry 500 rupees. It's not that our legal services boards don't have enough funds. They can certainly pay better, they can screen lawyers better so that this becomes something worthwhile and also becomes something of prestige. It should be recognized that you're doing important public interest work. Unfortunately, today, even the handful of legal aid lawyers who do this work are actually not their work is not appreciated and it's not seen in a positive way. So it's got, the legal aid services panel has got not a very good reputation because it's got a reputation of lawyers who are not doing the work well, who are really having no other practice. I think there should be other forms of incentivization as well. Now you also have in India a lot of organizations, NGOs, which are able to get support to do public interest work, where they can pay young lawyers well to do rights-based work, which many years ago was not possible. Today, I mean, earlier in the 60s, 70s, and 80s, either you do litigation, where you join a senior, or you join a solicitor firm. Today, you also have the option where you have a lot of organizations which are supported and funded and which can hire lawyers to do public interest work and pay them reasonably well. So, but I certainly think that there has to be some incentivization. The incentivization has to be across the legal system. And I think further, I think in the courts and in the legal profession, people who do legal aid work and who do public interest work have to be recognized as doing work that is seen to be really of worth. Today, unfortunately, in our courts, we have a sense within the, both in the bar and the judiciary, that someone who does really good corporate work is seen in a very positive light. You don't have the same way, public interest lawyers who do public interest work are not seen in the same way. So we have to change the way we look at people who do public interest work if we want this kind of work to increase.
Sir, good evening, Venkatraman, sir. A question to you. You told that it should be telecasted. Instead of that, I would like to know whether all the law schools in India have been integrated through website so that they can conduct a webinar live cast so that the students can make themselves. Number one, this is my part A question. And my part B question is, after 2000 IT Act has not been amended, after 1947 Industrial Dispute Act, only amendments were made. Factories Act 1948, only amendments were made. All the MNC companies are having their shop floor here. More migratory workers are in India. In case of crisis, if there are no amended laws or no new laws, how are you able to face their problems in case of crisis? IT employees, they do not have any association or anything like them, no union to them. In case of crisis, if there is no law, means there is no clear-cut law says that in case of IT industry goes on strike, how to face them. How are you going to face as a lawyer, sir? It is my part B question.
I have no disagreement on your first question. Webinar, see, these are all details. We just thought suggesting a couple of things. But we should expose our children to more of these experiences, which you can now relate it and connect it through a digital world. That's okay. As far as the second question is concerned, of course, I'm not a domain expert in labor law. Have had a few experiences of friends, spouses, and all those things getting into IT issues. The labor law in the country and the shop attack, all these enactments, they deal IT company cases also the same way they deal any other white-collared offense or white-collared mistake. So, ultimately, employer-employer relationship is the doctrine of pleasure. If an employee is sacked, you have ombudsman, all those things are there in IT companies. But ultimately, it's all lined up to ensure that the management's decision is final. So, fighting against the management, you will be sidelined in your progress as an individual. So, it's a challenge which every individual mind has to take, whether to fight or to give it up and then go and change jobs. It's like any other employment opportunity as far as laws are concerned. This is my basic understanding out of 3-4 experiences. I'm not an expert in this field, but this is my answer to your question. It is concerning, but this is how it is getting handled as a matter of fact.
This is just a popular statement. I wish it isn't true. There is this, somebody said, I argued the fourth matter in the first court and the first matter in the fourth court and managed to get a stay in both. So, but the message that I got was some persuasion skills of the lawyer who did this. So you were talking about advocacy, and both of you have, contributed a lot, successful lawyers, and there are so many of us here who want to know, if you want to pick the topmost advocacy skill that's made you what you are today, what would you pick, Mr. Venkatraman and Mr. Datar? Advocacy skill, because today it's about skills. So what would you think is the topmost that made the difference for both of you?
I'll just say one or two only. See, ultimately, it's a mind game and a time game, sir. I've seen it out of my experience, especially in a long matter. So, how do you time it? And what's the mood of the judge and the court at a given point of time? Molding yourself to the mood. But basically, these corporate laws are all quite standardized. You can't influence like a criminal trial or anything in a big way. Swing this way or that way. The options are really limited. But even within that, a judge can take a call one way or the other. So, molding yourself to the framework of the judge's thought process is all about advocacy. Because you have to win the matter using the correct principles of law, number one. Now, number two, he was saying 1 and 4 and 4 and 1. I think he would have he's experiencing, all of us are experiencing it. Same matter sometimes gets part heard thrice or 4 times before different benches. And it's a matter of fact. Every time, every court appreciates the same case differently. It's an experience. So, it's now especially where there is a discretion vested in a court, whether your type of thinking matters. A Vodafone judgment would have been an impossibility in the same Supreme Court had it been before any other bench. I can challenge it. It's only because somebody who knows chartered accountancy, somebody who knows economics, somebody knows what is investment market cycle, you could get a Vodafone judgment. So same if it has gone before judges who have a socialistic bent of mind, you would not have got this judgment this way. It's a chance. Ultimately, it's a chance.
Yeah, to answer your question, you said that the same case of one lawyer, why advocacy skill matters. But this is not now. If you read Cicero, what did Cicero say so many years? He said if truth were self-evident, eloquence would be unnecessary. So very often and I've seen as a youngster, I've seen Ram Jethmalani argue, I've seen X argue. There's a world of a difference. Ultimately, it's the art of persuasion. In fact, in the Palkiwala's book, they say the judge would reserve judgment for 2 days because he would be in a state of hypnosis after listening to him. So he wanted to be calm and then write the judgment. So ultimately, I think it's just the skill of persuasion and how to put your point. Secondly, again, it depends from court to court. When you've got half an hour, how to select the best 2 points. We have read books on advocacy. There's an leading American lawyer. He calls it the technique of spotlighting. He said ultimately in any case there are 2 or 3 focal points which will swing the case this way or that. So that your skill lies in analyzing that point and then deciding the case. So many examples are there where by sheer advocacy you can do. I just read a biography of Marshall Hall, one of the greatest jury lawyers. He was almost an actor. F.E. Smith, Lord Birkenhead, he used to write his entire arguments, rehearse them, and then put it. So just the sheer skill of persuading a person to say something, that's really matter. It's unfortunate, but that's true. Ultimately, it all depends on how you present. The same points ABC said by me will mean something, said by another great lawyer will mean something else. He may win the case, I may not win the case. No, I think these are all slightly exaggerations. Yeah, no, these are high exaggeration that you just go to court and without knowing the case, you go and argue. This is not true at all. Believe me, on important days, we don't sleep before midnight because you're preparing for a case. If I could just say this, I mean, I would be in a much different place.
But there was a period where Doyen's first item 1 will be a rent control matter for the landlord. Item 8, not different code, same day, item 8, rent control matter for the tenant. Both you will get a stay. It has happened. It's not that. But, well, we have evolved out of it today. That much is sure.
Hi all, my name is Pranit Reddy and I have a question regarding to Right to Education Act. And I believe Right to Education Act and Gram Nyayalaya's Act are most beautiful acts in the country and least bothered also. So the judiciary is being stepped into a vacuum of governance and I don't know how this crisis will resolve. There is no implementation of Right to Education Act in this country and even from 2010 to 2015, the number of cases in Supreme Court related to Right to Education Act are 49% of access to education. And even in Supreme Court, we have 49% means in the local governance, the centralization is not full of centralization.
No, sorry, it's not true. Right to Education Act is being implemented. In fact, I argued the case, we lost it in the Supreme Court. We said some provisions are not correct, but Right to Education Act is being implemented.
60% of the Right to Education Act, about 25% free
admitting 25%
education.
students free of cost, that is being implemented in school after school. I don't know
What I think you may be referring to is, since the Supreme Court exempted, the Supreme Court has exempted certain minority schools from, coverage of the right to education.
There are so many litigations in the Supreme Court.
But that was because of litigation. But in other cases, the Right to Education Act is being implemented.
Then we don't have local courts like Gramanyalaya, so...
That is not done. But I think the issue here is on legal education and how we can, strengthen legal education. So if we could take up some questions on that.
Sorry, I come to the stage here because I've been a teacher and my son is also an advocate. The subject was, which is very clear here, do our law schools produce world-class lawyers? And Mr. Datar, he said yes, but he didn't elaborate there. Because he's saying that we have got how many, 80,000 advocates in Chennai, only in Chennai, in Tamil Nadu.
No, Tamil 90, I said we produce world-class lawyers, but not enough of them.
How many?
Pardon me?
How many?
17 lakhs.
17 lakh. 17 lakh advocates are there. Even then, we have got 28 million cases pending in the courts. Is it because of the low quality of judges or the low quality of advocates? Or though there are not many, Ram Jeshmanani, Arvind Datar, Venkatraman, to argue the cases? Because this is basic question is everybody talking about pendency of cases, but nobody is giving the answer why. Because I'm completing the question. That clients wants the best lawyers. Everybody wants Arvind, everybody wants Venkatraman, everybody wants Hari Salve. Why we don't have duplicate Ram Jeshmanani, triplicate Arvind Datar, fourth time Mr. Venkatraman? Because there is only one Arvind Datar, there is one Ram Jeshmanani. It means we don't have even national class lawyers who can argue to the satisfaction of the clients. So obviously our law schools are not producing advocates in which the clients should have faith because their teaching shops are there. And as they say, it is one of the most cheapest education. Investment in education is less, but return in this profession is the highest. You spend only 7 to 8 lakh rupees a year on education, law education, and you earn that 7 to 8 lakh rupees in most of the advocates, some of them in a half a day. There are many who earn in 1 day. There are others who are earning 1 month. So whatever you invest in law education, you get it back in 1 month. So this is the cheapest thing. Therefore, you have got a lot of supply. But clients are still suffering. It's the most cost of litigation is the highest. But world-class advocates are missing because that is the question we want to raise. Pendency of delivery of justice in this country is delayed because of the judges, because of the advocates, or because of the infrastructure. I want both of you to give a short answer and be frank with it.
Yes. I'll just...
Because of the adjournments, cases are pending. Most of the cases,
yes.
Every day I see so many adjournments happening.
No, I'll just answer one thing. One is the issue of pendency and the other issue of competence. On the issue of pendency, the simple answer is we have the lowest judge to population ratio. We have only 11 judges per million, whereas the United Nations norm is 100 judges per million. In 2002, the Supreme Court said that you must have at least bring it up to 50 judges per million. But that has still not been done after so many. We have got some 13.7 judges per million. So one is a chronic shortage of judges. Secondly, if you take the percentage of expenditure on judiciary, it's I think 0.6% or 0.4% of our GDP, whereas in the UK it is 6 to 7% of the GDP. So one reason is just pure lack of infrastructure. You all know that we have got a sanction strength of about 1,000 High Court judges and 40% shortage is there. So if you have less number of judges, you are going to have, to that extent, lesser number of disposals. So pendency is partly because of lack of the total number of judges. Secondly, the other reason pendency is wherever the litigant is the government, they will fight every case, good, bad, up to the Supreme Court. Today I was talking to judge. Most of the cases in the lower courts are check bouncing cases and domestic violence cases. They said we don't have time to do a 302 murder case, to do a grievous hurt case, to do a theft case. In fact, people are saying police are not registering FIRs for these offences because there is no court. The entire time is taken in check bouncing. Nowhere in the world check bouncing is an offence. We have made it an offence. So 40% of our cases are check bouncing, the remaining 40% are domestic violence. So that's one thing. As far as world-class lawyers, why you can't have double Jetpanani, etc., that will never happen. Otherwise, there will not be Ram Jetpanani at all. But I'm just saying that over the years, if you say as a percentage, I think today there are far more percentage of competent lawyers. You may just hear of one Palkiola, one Salve. There are so many other people who are very good who are not heard in the public domain, and they are doing wonderful work. They are the unsung heroes.
I have a different... I'm Dr. Hanifa Ghosh from Principal of CTT College. Just one question which has always intrigued me.
Excuse me, ma'am, before you ask your question, we have our panelist who's also adding on to the previous question. So if you would just wait for a bit, we'll also hear his thoughts.
Okay, sure. I'm sorry about that.
Yes.
I'll just take 2 minutes. I have a different perception on dependency because I worked on it and a paper for the National Judicial Academy for Judges. When I did the research, it was what featured ultimately in the analysis is we are actually burdening the courts. It's non-disposal is one part of it. It is the executive who is the biggest litigant today in the country. On what 8 out of 10 issues which need not be either issues or something which they could have resolved it themselves, they have now pushed it to the courts. So you burden the court 8 or 10 times more and extract, say that you have not produced results, whether it is justified. It is something, so it's an alignment of all the 3 bodies. If they must talk it out. They must sort it out. You don't identify only judiciary and then point out to say pendency is because of you. This mismatch can considerably reduce pendency. 1. 2. Multiple high courts are deciding the same issue. For example, if it's an ATA exemption, when one high court puts it, transfer it, bunch all the cases to one high court. Why should 10 different high courts hear 10 different benches for 6 days? These are all small things which we can do. We can add value and reduce standard. Within the limitation of the allotment, all those resources constraint will be there. A meaningful reduction, some semblance of a result can be brought out if we do course correction in this way. And on competence, it's a matter of personal ethics. I have been in Delhi for the past 5 years. It's my commitment. I normally don't take a second matter. If I take it, it has to be in the same court or in the same vicinity. It's a matter of ethics, that's all. If you commit for 3 places and you make your client swing where he will be at a time, people chase, that's different. But you have to decide where to draw a line. And more number of people are emerging, sir. In next 10 to 15 years, as Datar predicts, finds it out, you will, because now clients are, people tolerated, clients tolerated. Now clients are not willing to tolerate. Because they say, we want your time and we are paying you. Therefore, they want to extract. So there is now a mismatch which is slowly getting filled up. 10 to 15 years, you will see the difference.
Thank you, sir. The last question for this session, ma'am, very quickly.
Thank you. I'm Dr. Hanifa Ghosh, Principal of CTT College. I've always been intrigued by this question, by the ethics of this profession. Does a lawyer need to be convinced of the innocence of his client before he takes up a case?
We'll bask on the statement of our Bhishma Pitamagar K. Parasaran sir. It is always good to remain ethical. Let's be clear. But for every golden rule, there are golden exceptions. Sometimes you are fraught with those exceptions. But as a lawyer, you still fight your case only under the principles of law. I think none of us would have fudged because we all belong to, see, what motivates you? Ultimately, your senior motivates you. My senior judges have never opened the bundle when he stood up and spoke. So that's something which has inspired me as a youngster. So, because he was ethical. So you fight even a case on law, I think it is permissible under the terminology advocacy.
I'll just answer your question because my senior was a leading criminal lawyer. First of all, the moment you decide, then you step into the role of a judge. You're a lawyer. Suppose you got a case of murder. You know the client has murdered. But then you see, are there any exceptions? Your duty is not to make any false statement, not to make any false records. But was it grave and sudden provocation? Was he mentally stable at that point of time? So whatever defenses are available to you in law, you can always put forth. So even if your client is, because everybody is entitled to a defense, even the most criminal has some redeeming feature, you can try to put that and mitigate the sentence. Instead of death, you can bring it to life or bring it to 10. You can convert 302 into grievous hurt. You can do by just putting forth the best possible things. See, a person may commit murder with grave and sudden provocation. That's not a ground to convict him.
Thank you very much. And that ends our panel discussion. A big hand to our panelists. Thank you very, very much. I think we asked the question, do our law schools produce world-class lawyers? And we discussed a whole gamut of things and learned a lot from you as well, starting from the curriculum and the kind of courses that are available to the need for practical education, so on and so forth. Thank you very, very much for joining us. May I request Mr. Prabhu Chawla to kindly join us on stage and felicitate our panelists.
Let's hope 25 years from now, a couple of you or more of you come here to say that we have become experts all over the place.
Ladies and gentlemen, we have one last session, our special session with a very, very special eminent person. So please kindly stay back for that. We're going to start immediately. Thank you. Thank you for joining us and making this session all the more entertaining and invigorating. Thank you very, very much.